Okay, so my name's Hirak. So we're going to talk about, as you guys know, Citizens United, money and politics. And we're going to have our speakers. So we'll have Danielle do an introduction. I'll basically do a little bit of a run through so we all know what we're talking about. So let's warm up our minds a little bit. Dr. Batchis will get into nitty-gritty of it. And then James will, tell us about the aftermath of Citizens United and what exactly is money and politics. So, Danielle, why don't you get started?
Good afternoon, my name is Danielle Metcalfe. So a few years ago, I was contemplating, as many of us do in our early 20s, how was I going to change the world? I could spend my life working on any number of the world's problems, but where to begin? I credit my current path to Cenk Uygur, who is the founder of the progressive news media outlet known as the Young Turks. One evening I was finding the end of the internet, as we often find ourselves doing these days, and when I stumbled across Cenk talking about money and politics. He quoted Lawrence Lessig, who points out that money and politics isn't the number one issue in America, but it needs to be the first issue. As long as money equals speech in this country, our government will fail to represent the vast majority of us who can't afford to hire K Street lobbyists or exorbitant campaign contributions. It really doesn't matter what issues you care about, whether you're liberal or conservative, money and politics hurts all of us. So that day I decided to sign up to be a volunteer with WolfPAC, whose mission is to pressure Congress into drafting a campaign finance amendment by getting state legislators to call for an Article 5 convention. The Delaware WolfPAC chapter has now evolved into a local movement called Delaware Get Money Out. There are many voices across the country working on this issue, such as 99 Rise and Move to Amend. But I am most looking forward to Democracy Spring coming this April, where we will march from Philadelphia to DC to demand Congress take action. I care so deeply about this issue, I will be among the 2,000 people risking arrest in DC on April 11th while staging nonviolent sit-ins at the Capitol. I hope after hearing this presentation, some of you will be inspired to take action too, and if you have any questions or want to get involved, please approach me afterward and I will push you in the right direction. Our first speaker is president of the UD College Democrats. Prior to that, he was a general member of the Director of Development. A junior majoring in political science, he got interested in campaign finance after researching Citizens United for an essay contest. Although he did not win, he used the material from the contest and reformatted it into an article on the UD College Democrats website about Citizens United and how it is remarkably incorrect. Using that material, along with new research, we will hear a summary of prior campaign finance decisions before Citizens United and briefly explain what exactly happened in Citizens United before Dr. Batchis goes into a complex analysis of that case. Here is Hirak Mukhopadhyay.
All right. Thank you, Danielle, for the introduction. Again, thank you all for being here. All right, so I want to start with where we are in the Supreme Court. So as you guys know today, the court's going to change a little bit. Merrick Garland, Chief Judge of the D.C. Circuit Court, will now hopefully be a Supreme Court Justice. But I want to talk about what Charles Freed at Harvard Law School calls the unraveling at the Supreme Court. So Chief Justice Roberts, this has been a very interesting about roughly 10 years. When we had Chief Justice Berger, Chief Justice Rehnquist, sure they were conservatives, but there was an aspect there where there was a lot of compromise between the liberals of the court and the conservatives in the court. Now, given the Roberts Court's current belief in very, very outright conservative principles, very strong beliefs, strong sense of libertarianism, that compromise has seemed to disappear. Hence, it is called the unraveling of really the conservative wing of the Supreme Court. And we see that certainly in campaign finance, in Citizens United, and also in McCutcheon. So, in my mind, the Citizens United decision is not only arrogant, it is a lack of respect for precedent that has been established. It's arbitrary. It is the justices set the law the way they see fit, and it ignores and dismisses decades of constitutional jurisprudence. And in my mind, it is judicial activism gone way wrong. So let's start with some of the other cases before Citizens United and see what they had, what the justices had, and we'll go into Citizens United and what exactly happened in that case. before Dr. Batchis gives us some more analysis. Okay, so Buckley v. Valeo was in 1976. It was a case where Senator Buckley of New York, who was very conservative, very Republican justice, was dismayed at the new amendments made to the Federal Election Campaign Act, which limited two aspects of campaign finance: campaign contributions and campaign expenditures, as in campaign spending. So campaign spending and contributions are two different things in campaign finance. He believed this was a violation of the First Amendment, so he sued and he went all the way to the Supreme Court. And the Supreme Court basically came to a compromise, as I mentioned earlier. They believed that the contributions being limited and restricted and regulated was not a violation of the First Amendment on the grounds that it maintains it avoids corruption or the appearance of corruption. The regulations also had a provision where you disclose who is making these big contributions to the candidates. And although this is a violation of privacy to some degree, the electorate and the general population has the right to know who is pitching in this money to these elections. But what they did strike down was the act regarding the campaign expenditures, also known as campaign spending. Now, campaigns cannot, I don't think this was a question of direct spending of the campaign, but it was the question of independent expenditures. So someone who's not related to the campaign, but I want to do a fundraiser for this candidate, or I want to, pay for the float for some parade. So independent campaign spending was limited. Personal campaign spending, so if someone wanted to use their own bank account, or their fiance's bank account, or if they were old, their college student child's bank account for campaign expenses, those were all limited, and the combination of all those things was limited. So the Supreme Court said, no, this is a violation of the First Amendment. These should not be limited. So and then 2 years later, we had another case called First National Bank of Boston versus Bellotti. This was a little bit of a different case. This was regarding campaign communication, so advertising, commercials, infomercials. So the question was regarding a referendum. Are you all familiar with? So referendum it's like when Colorado had a vote on whether or not to legalize recreational marijuana, and everyone in the state voted. That's an example of referendum. It's basically democracy in the purest form. So the question was, can a corporation fund these commercials and air them? Can Goldman Sachs put on an ad and say, hey, vote yes to Massachusetts Bill 3? Can Citigroup or Shell Oil put on a commercial with a lot of jargon, a lot of rhetoric, and say, hey, vote no to House Bill 2? And the court said that corporations do have a right to make these commercials under the First Amendment and free speech principle. They do have a right to influence politics, even if these issues are not related to what they are, to their everyday business activities. They can still do it. So, for example, let's say Apple's in California. So Apple Computer in the 1980s was supportive of gay marriage. And California, let's assume in the 1980s California was supportive of gay marriage, and they're going to have a referendum. Everyone in the state gets to vote, yes or no. Now, whether gay marriage or not gets accepted, it doesn't have any impact on the making of Apple computers. But under this case, they could have had a commercial saying, hey, love is love, let's have gay marriage, and let's have marriage equality. And that would have been constitutional under the Bellotti case. So a few years later, we get back into election finance, and we had Austin versus Michigan Chamber of Commerce. So again, the question of independent expenditures comes back. So the state of Michigan, their legislature passed a bunch of regulations regarding independent campaign spending. But there was a loophole to this law, which was only corporations are bound by it. So labor unions, nonprofit organizations, they can spend as much as they want. Now, you were allowed as a corporation to spend, but it was very difficult. There was a lot of obstacles, a lot of hoops to jump through. So the Michigan Chamber of Commerce realized this, and they tried to get exempt status as a nonprofit. And when they realized it didn't work, they tried to sue under the First Amendment and the 14th Amendment of the Equal Protection Clause, which is the application of the Bill of Rights to the states, because it was a Michigan regulation. So the Supreme Court was like, haha, you tried it, nice try. No, you are not a nonprofit. The Michigan Chamber of Commerce has wealthy CEOs, wealthy corporations, banks, financial institutions who are actually members of the Michigan Chamber of Commerce. They have ties to the business community, ties to the famous business members in the state of Michigan. So to us, this looks like a corporation, not a nonprofit. And we will keep these regulational independent expenditures for the exact same reason Buckley kept them, which was the corruption or the appearance of corruption or unfair influence of money into our political system. Now, in this process, we also had some legislation. So it sounds crazy now, but we actually had a Republican and a Democrat come together and try to stop all the holes and all the crevices of where money can leak, called the Bipartisan Reform Campaign Act, also known as McCain-Feingold, because it was John McCain and Russ Feingold. Yeah, it's hard to believe now, but it passed. President Bush signed it. And this was really, it basically tried to, like I said, put a stop on whatever these other cases didn't cover. So soft money contributions in campaigns, hard money contributions in campaigns, and it also did the controversial activity of limiting campaign commercials by both the political parties, corporations, unions, nonprofits before a primary election. And they knew this was going to go to the Supreme Court. Mitch McConnell, being the senator that he is, he challenged this right away. John McCain and Feingold were ready. The Supreme Court took it, and they said, and so the question was, do the commercials violate Article 1, Section 4 of the Constitution and the First Amendment? And does the soft money regulation also violate free speech because money is speech and you're violating the First Amendment? The Supreme Court, in a huge victory really for the liberals, again, very hard to believe now, they said no on both counts. This soft money bans were not really seen as a First Amendment issue because soft money is really, it's like helping citizens get registered to vote or like passing out campaign literature. They didn't really see it as that big of a deal. And again, they go back to the same exact point: unfair influence of money in politics, corruption. There was a quote, "Money like water will always find an outlet." So that was the state of our campaign finance until Citizens United. And I would say I agreed with all of the prior decisions of the majority. But after Citizens United, I'm afraid I cannot say that anymore. So Citizens United. So there was a group called Citizens United, very conservative, really just, propaganda in the United States for the conservative movement. They wanted to air a documentary on Hillary Clinton and, the Whitewater scandal and stuff she did in Arkansas and all this really unproven, but, they thought it would make a difference. The McCain-Feingold Act, it prohibited playing, this was basically a documentary, but they held it as communications before an election. So they knew, again, it was going to get shut down, so they took it to the Supreme Court. The Supreme Court accepted the case, and does the ban by McCain-Feingold on the Hillary documentary violate the First Amendment? The court said, yes, this is a violation of free speech to not broadcast it. It is also a violation of free speech to ban the proper funds and campaign spending. So basically what they're saying is it's campaign spending against Hillary Clinton. So it's not for her campaign, but it's against her campaign. To ban that funding was also a violation of free speech. Those two questions alone would have settled the issue of Citizens United, and we could have moved on to the next case, whatever it was. But the conservatives of the court, they were like, all right, well, while we're looking at the McCain-Feingold Act, you know what, let's just strike all of it down. Most of whatever's in it, we don't like it anyway. It's up here. So instead of just calling it a day like what most legal scholars, what most justices would have done, they actually ended up banning the regulation of almost all campaign expenditures, They basically banned they banned the limit of all independent expenditures by corporations, labor unions, nonprofits, in-betweens, whatever. So the regulations that McCain-Feingold and the Austin case placed, you know what? It's all wrong. We don't like it. It's a violation of free speech. Free speech is absolute and unlimited, which is a terrible idea anyway. I mean, if you think Donald Trump is bad, wait till you see what full free speech is like. So, but nonetheless, that's what they believed. So, the independent expenditures regulation on independent spending is gone. Corporations can now spend, not just for commercials, just in general. They can all spend, no limits, bring all that money, go ahead, have at it. Austin, the case I mentioned a few minutes earlier, it's completely wrong. You know, it was never right. We're right. I don't care what Austin said. And then in 2014, we saw a similar thing again. So the independent expenditures, like I said, that regulation is gone. But as you may remember, in Buckley, the campaign contribution section was still there of limitation and regulations of campaign financing when it comes to the actual money given to the candidate. Not how they spend it, but the actual money. And they're two different things. So in McCutcheon, of course, someone sues on the grounds of, oh, I don't think limiting contributions is constitutional. And the Supreme Court says, you're right, contributions, those should not have been limited either. The compromise that Buckley and Valeo, that the old vanguard, the Warren Court, and the new court and the Berger Court, the fact that they were able to agree, I don't care, it's wrong. The Buckley regulation on contribution in terms of avoiding corruption, it is wrong. It's a violation of free speech because free speech is completely unlimited according to the Roberts, Thomas, Scalia, Alito, Kennedy court, or wing of the court. So Buckley gets gutted. So we have this term, money in politics. So the reason why we have it, and the reason why Citizens United catches as much flack as it does, is because Austin, the precedent that's set, gone. A lot of it is gone. Most of it is gutted. Buckley, again, most of it is gutted. The McCain-Feingold Act, most of it, even though it was an act of Congress, the court decided, no, we're not going to go with it. So that is mostly gone. So in the Citizens United case, they also said that because Bellotti allowed corporate contributions to commercials, that applies to Citizens United. But what they don't realize is in Bellotti there were no elections, there were no seats in the legislature up for grabs. It was a matter of enacting state policy. So state policy and electing actual officials, actual members, the composition of a legislature or a Senate or a Supreme Court, for example, Pennsylvania Supreme Court actually has elections. That and enacting a state policy by pure democratic means are two very different things. Yet in the majority of Citizens United, they said it worked in Bellotti, so it'll work now. You know, even if they're two different things, once again, I think the connection is there. But Bellotti never answered the question of whether elections can have corporate influence. When Justice Powell, who wrote the majority in Bellotti of corporations have a right to mold politics, he was never given this question. When Justice Powell, before he was on the court, wrote an essay about how corporations don't participate in politics enough. In that thing known as the Powell Memorandum, and it's also known, and that memo is also cited for really starting the free market conservative movement that we have now. It never mentioned that, oh, our elections are too regulated, oh, public financing of elections are bad, or, you know, corporations should contribute more to elections. It was much more on narrow terms. It was basically saying corporations have a right to contribute. And that is something even the liberals of the Supreme Court have agreed with time and time again. So I will leave you with this. All of these cases talk about corruption, unfair influence in politics, unfair influence in politics, undue influence in politics. I written down multiple cases that mention these multiple times in the majority opinion. Yet, after decades, Justice Kennedy says, no, I don't think it's there. These accusations of corruption, I don't believe them. I don't believe they're substantiated. I believe in our system, even though time and time again, corruption has been mentioned. So that is basically the introduction to what we're going to be talking about. it's not really the most rosy picture, but America. So we will have Dr. Batchis talk about the legal things a little bit more complicated, or we'll talk about the more complicated issues. That is money really speech? Is the First Amendment really applicable here? Dr. Batchis is a professor of, I would say, legal studies and political science. Both departments. He was an attorney for several years, attended University of Pennsylvania Law School and Johns Hopkins for his PhD, has been published in the New York Times, in the Stanford Civil Liberties Journal, and another journal at the New York University School of Law. We'll also have James, who's also part of Democrats, who will actually talk about how do the financials look after this decision? What does the money coming in look like? Are the rich and the powerful and the wealthy really contributing more, as the media and some liberals say? And how are these candidates that the wealthy and the corporations are pushing, how are they doing in these elections? And yeah, that's it. So thank you very much.
Yeah. All right. Hello. Thank you, Hirak, for inviting me. I'm glad to be able to talk to you today. For those of you who are interested in this subject, if you're a student, take my election law class next semester. I'd love to have you. We spend several weeks on this material, so if you're interested in it, please look into that class. So here we are, right? We're in the thick of what is perhaps one of the most hard to even believe primary campaigns. It's a very strange reality that we're living through right now. And even before this mayhem that we're living through, especially with regard to the Republican primaries, a lot of people, a lot of Americans felt pretty disgusted by the process, by elections, by our elected officials. Just look at the approval ratings of Congress. But the issue of campaign finance, right? Campaign finance reform and campaign finance laws generally generally this is seen as a pretty boring, pretty dry topic, and it's hard to get into. It's hard to while people have strong feelings, right? It's hard to understand, to pull apart and really kind of get a clear sense of what's going on. So let me just start by Hirak did an excellent job, I think, giving us some background. The first campaign finance laws go back to Theodore Roosevelt and the Tillman Act over 100 years ago. But let's start with maybe a question that seems kind of obvious, right? You're all here probably because you have answers in your head to this question. But why do we care that campaigns have become so expensive? We're kind of working off the assumption that there's something wrong here, right? Why does it matter? Why is it a problem that campaigns are so, year after year after year, they only get more and more expensive? So what? So what? Does anyone have any thoughts? Well, if you get upset about this, if you do some thinking about this issue, what are your feelings? Go ahead.
Definitely just based on the idea that our republic is based on representative democracy, so that people are supposed to have some say in who the representatives are, and they're supposed to be responsive to people, and if they're not doing what the people want, then you can vote them out of office in the next election. And this process seems to sort of take that power and some of the democratic rights that I think the citizenry has and take it out of the people's hands, and either misinforming them through think tanks and just different political jargon, or just directly manipulating candidates into like saying or acting one way and then maybe doing something else later, and it's just formed a really disingenuous system.
Okay, so the fact that it's so costly means what? That those who are paying the bills are not generally ordinary Americans, and those who are paying the bills we might assume have disproportionate influence, right, over our elected officials. Sure, right? That's a concern. That's a concern. People with more money become more influential. What happens to democracy? What else? Go ahead.
It disturbs me that 94% of federal elections are won by the candidate who raised the most money. So as somebody who's running to want to be in Congress or to be an elected official, you can't really fight against those odds. You have to play the game to want to be able to do any good whatsoever. And then once you get in, you have to spend around 20 hours a week fundraising to be able to get reelected if you want to keep doing your job. And I can't imagine what it would be like for 20 hours out of my work week that I have to beg for money just so that I can stay and do my job. And then what kind of people that draws in. You know, because it definitely dissuades people who really just want to do their job, right, and do good for the people. And I think it entices people who want to come in and for their own personal interests.
Okay, so great. So you mentioned a couple things there, right? That it's not only about influence, but it's about really an unfair advantage to those who are able to bring in the most money. It makes it very hard for others who don't have those kinds of financial resources to compete. And then you make another really important point that sometimes is not raised. I'm glad you raised it, and that is then you have a system that requires our elected leaders, right, to be constantly raising money. In political science, we sometimes refer to that as the permanent campaign. Right? A huge portion of your time as an elected official then needs to be dedicated to raising money. Absolutely. What else? And there are other concerns we might have. Go ahead.
One word that comes up to my mind is access. So I think echoing some of the other concerns, just think about sort of the intent of our democracy being a representative one. That again, sort of echoing the same concerns that people who are seeking office will then have to ask for money rather than have sort of more of an, I guess, an even playing field. So people wanting to enter sort of the position of, say, being a senator or legislator would have to go through this process, and not everyone has access to these channels. And the other part of that is on the other end of the electorate, having access to information. So, like, if you look at what the actual money is being spent on, it's being spent on commercials and all other information or propaganda. And so then the information about the issues about which people should be concerned to be voting on, those are the issues which are being pushed forth through these different channels. And so having access to information about what the actual concerns are, what actual legislation is being pushed through, that sometimes gets lost in the whole.
Okay, two great points, right? All the spending that's a result of all this money means that the spending is going to be used to disseminate certain information, right? To make certain points, perhaps at the exclusion of others, to provide certain information but not other information, that will distort the democratic process. It will distort people's ability to see the bigger picture because all they're going to hear is the clamor coming from the big money sources when it comes to what information they're fed. So that's a good point. All right, there's also what you talked about. Right, we talked about political advantages of having money. It makes it harder to run. Also, influence. Those who support, candidates with money might tend to have more influence. We also might that might also cross the line, right? What happens suddenly when it's about if you're a big contributor, you might have the ear of a particular politician because hey, you help them a lot. The least they can do is listen to you when you have a concern. It might go further than that, though, right? And what's the most extreme version of that? That's when we start using the C word. Right? What is the C word, Hirak? You've used it many times. That's the C word. But I was thinking, corruption, right? Corruption. When do you cross the line into corruption? When does all that money? And what's the most obvious example? Right? Bribery. Right? I will give you X amount of money, and you vote in this way. Right? When you're presented with this legislation, it's going to help my company, it's going to help me, so I'll pay you off, right? That's illegal. That's clearly illegal. That's clearly corruption. Where you draw the line and where you say you have an instance of actual bribery, and where there's just some pressure, right? But it's not so explicit. And whether you call that corruption too, it's an open question. But sure, yeah, so this is great. So there's lots of reasons, right? There's lots of reasons here to be concerned. I wanted to kind of get that out because I know you're probably all here because you're concerned, but there really are it's a long list of reasons we might be worried about all of this money in our political process. So we understand that, back to Buckley, that the court saw a relationship between political spending or money in the system and the First Amendment and free speech. Now Buckley, I hope I'm not repeating Hirak here too much, but I think it's really important to understand Citizens United to talk about Buckley versus Valeo, because it's such an important decision from the 1970s, addressing the Federal Election Campaign Act, or FECA. FECA was a law that came out of the Watergate scandal in the 1970s with a whole new regime for regulating campaign financing. Very, very complex set of laws. And you see, right, it was the water line about money flowing like water. To attack this problem effectively is not simple. It's very difficult because there's so many routes money can travel. So you end up with really, really complex pieces of legislation, which again I think causes people to sort of disengage because it's so complicated. But Hirak was right, and I'll just revisit the crux of Buckley had to do with this distinction between contributions and expenditures, right? Contributions and expenditures. What's the difference? When you contribute to a politician's campaign, you say, right, self, I really like that Bernie Sanders, I want him to be president, I'm going to give him $100 to make him, to allow him to do things he needs for his campaign in order to win. That's a contribution. Right? An expenditure is, well, it could be I am Bernie Sanders, I have $100, I'm going to spend that $100 printing up some brochures that I'm going to distribute when I'm in Philadelphia. All right, what's the relationship first between a contribution, that first scenario, and free speech protected by the First Amendment? Well, when does a contribution, you're Bernie Sanders, here you go, Bernie, right? Where is there a free speech issue? Does that raise, in your mind, does a common sense response to that lead you to believe, yeah, there's a free speech concern there? Is there any speech going on there when I'm handing that $100 bill to Bernie Sanders? Go ahead.
What is the phrase? Money talks, right? You vote with your dollars. So in many ways, when we're all very stingy with our money. So if you give anybody any of your money, that's you voicing that you support them or you approve of it. So I think that's where this.
Okay. So yeah, I'm maybe spent some time as a socialist in Brooklyn too, and I think Brooklyn, I think that Bernie Sanders can speak for me, and I'm contributing money to his campaign so he can speak. I can speak through him, right? That's true. The act of handing that $100 bill over to Bernie, right? That in itself, you might say, is a sort of symbolic expression. Right? I'm expressing my support for the candidate. It's a way of expressing my political views. Right? The court says contributions do raise First Amendment concerns. Right? There is a speech component here. But in Buckley, as Hirak told us, the court said limiting contributions is constitutional. So why? Why? On one hand, the court says, yeah, this definitely calls forth free speech concerns. On the other hand, we're going to allow. We're going to allow a restriction, a cap on how much we can contribute to a candidate. Well, right, the court says we have to balance. Right? We see that there's a First Amendment issue, but we also see that there are some serious concerns about not limiting contributions. And what concerns did the court focus on? And I bet you know, Hirak. What concerns were key to the court saying, on balance, even though we see there is a free speech interest here, we're going to allow restrictions on contributions. And why? What is the concern?
Corruption, bribery.
Corruption.
Watergate just happened. So.
Corruption.
Representative democracy, really.
Corruption, or the appearance of corruption, because it looks like it's not a $100 bill, if it's a suitcase with $1 million in it, right? That starts to look bad. That looks like corruption, even if it's not actual corruption. Even I'm just really enthusiastic. I want nothing in return from Bernie, right? If I hand him that suitcase with $1 million in it, it might create the appearance of corruption. So the court says there are basically two reasons we might allow for a counterbalance to free speech, and that is corruption or the appearance of corruption. Buying results from our elected leaders. So the court says ultimately contribution limits are constitutional, but in stark contrast, what about expenditures, right? The court in Buckley strikes down expenditure limitations, as Hirak told us. Why strike down expenditure limitations? Considering, if you can think about what the basis was for allowing restrictions on contributions, how about if you apply that same argument, corruption, appearance of corruption, to expenditures? Well, what is the court reason? Go ahead.
Well, I don't know the exact reason, I don't remember specifically, but
Yeah.
the way I understand it, like, if you're cutting off the spout of, like, the money, like, it doesn't ever get into the system where it becomes a danger. Like, if they're spending money that they've raised, that it's under all the limits that you set, and they're not, appearing corrupt, then what does it matter what they actually spend?
Well, right, okay, and if they're spending what? They're spending their own money, right? And Hirak referred to this as well. If it's their own money, and they're doing it on their own, is there a worry that they're buying votes, right? No. I mean, or at least in theory, if things were that simple, on its face, it looks like the concern about corruption is much less than with a contribution, because you're not buying anything from anyone, you're just spending your own money to voice your own ideas. Right? Spending my own money to air those commercials. Right? But of course, we talked about all those other reasons where you might be concerned about money in politics, right? The unfair advantage it might provide to those with more resources, the amount of time it takes, right, to raise money, and the way it almost overwhelms governing, because it's so crucial. What about those concerns? What about the fact that someone with enormous amounts of money they're in a position to have a huge advantage, or to provide a politician with a huge advantage just by spending enormous amounts of money? What does the court say about that claim? No, right? We're not going to we don't accept that argument. We don't accept any other argument except corruption and the appearance of corruption as a counterbalance to free speech. One of the most cited lines from Buckley is the court's statement that the concept that the government may restrict the speech of some in order to enhance the relative voice of others is wholly foreign to the First Amendment. Kind of sounds like socialism, right? And they said, no, we're not. We're not going there. Corruption, appearance of corruption, okay, but all of these other reasons that you might emphasize when talking about the need or the problem of money in politics, we're not going to accept those at all as legitimate arguments for curtailing freedom of speech. Okay, so leveling the playing field is never a justification. Never a justification. And so what the court did is the court split the baby in Buckley, and we ended up with the court really made hash of this very complex, comprehensive attempt in the 1970s to deal with the problem of money in politics. All right, so then we lived with this for a very long time, and then we ended up with campaign with in 2002 McCain-Feingold, and that ultimately led to Citizens United from 2010, which came out of that most recent attempt, now 14 years ago, to address the problems we were left with after Buckley versus Valeo, which left enormous opportunities for finding loopholes to actually influence politics with money. All right, so I'm gonna zip ahead a little. Under McCain-Feingold, corporations were prohibited from using their treasury funds to advocate for the election or defeat of candidates 60 days before a general election, 30 days before a primary election. Since the passage of the original campaign finance law in the 70s, corporations were required to do what? They were required to raise money through something called a PAC. So first of all, let's talk about PACs a little bit. What is a PAC? Right, it's a political action committee. Does anyone know what the point of a PAC is? Besides Stephen Colbert, good comedy. What's a PAC?
So, for example, Delaware Action for Animals is a PAC in Delaware. So we collect money from our members, and then we give it to members that are running who support legislation that's pro-animals. So it's a way for people to either as conservative or liberal or specific issues that they care about to collect money and one way and then give it to candidates.
You got it. All right, great. All right, so PACs were designed to allow people to come together, to associate, to pool their money in order to promote certain political ideas, right? They're highly regulated entities, but from the perspective of corporations, right, they allow corporations to do the same thing, to pool money from shareholders, from employees of their corporation who wanted to support the ideas that they wanted to support, and then they could use that PAC as a vehicle to communicate those ideas. So you might think of, here's a company. Let's call it Fracking Unlimited, or FU for short. A big successful energy company in Pennsylvania, largely reliant on unregulated hydraulic fracturing, and they're doing very well for themselves. Fracking Unlimited is let's say it's a large publicly traded company, has millions of shareholders. Okay? So tons of shareholders. A lot of these shareholders probably own Fracking Unlimited. It's part of a mutual fund. Maybe it's your grandmother, and it's going to mean she's going to have a decent retirement. Right? Shareholders of Fracking Unlimited. They own it, right? They own a part of it. They want to see it succeed. Sure, they want to see the value of their shares increase, right? But is there any reason, perhaps, you as a shareholder might still not want Fracking Unlimited to use the money that you've contributed to its existence to support candidates who want to deregulate even more fracking? Why would you care, right? You want, if Fracking Unlimited thinks this is in its interest to support certain candidates who are going to further deregulate fracking, is there a reason you might not want Fracking Unlimited to spend money on that message? What do you think? Yeah, right. I mean, you might be torn. Like that's what it means to be human sometimes, right? Your financial interest might tell you, yeah, I want this, this politician who's going to help the prospects of this company that I own a portion of. It's going to help. If we elect them, they're going to do the right things. Fracking Unlimited. On the other hand, you might care about the environment, right? You might not want your money to be used, even though you generally support what is good for Fracking Unlimited, used to support those kinds of candidates. So, right, we have PACs, right? We have PACs, and it allows Fracking Unlimited to create a separate entity, and then Fracking Unlimited can say, we want to support candidate X. He's very anti-fracking regulation. Please contribute to FUPAC, right? And some might contribute, some might not. Some employees might also contribute. And the point is, right? The idea behind that is, hey, this is free speech in action. For those who want to come together and have a message they want to convey, we have a vehicle. The government created a vehicle for them to do it. Before Citizens United, this is the way things worked. This is the way a corporation that wanted to convey a message would go about conveying that political message. However, right, after Citizens United, this kind of protection, and essentially it is protection for shareholders, was scrapped. Right? It was the corporation, according to the court in Citizens United, that was being stripped of its First Amendment free speech rights, and PACs simply were not a sufficient way to provide them with their First Amendment rights. Because after all, a PAC is not, it's not FU, right? It's not the same organization. They have to spend extra money setting up this separate entity, and it's costly. So this is not a sufficient response to the concern that Fracking Unlimited and other corporations are deprived of their free speech rights in the limitation on their ability to spend to support particular candidates. Okay, the response, of course, their response to the shareholder argument is what? The dissenters make this argument. They say, well, what about protecting the shareholder from being forced, if they don't want to send a message about a particular candidate? They say, well, hey, what can a shareholder do? If a shareholder's not happy with how the corporation it owns shares in is spending money, they can always sell their shares, right? Simple as that. There's a reason to question whether it's that realistic, right, to expect that shareholders will do that, especially, grandma and grandpa who own essentially the equivalent of thousands of corporations through mutual funds. Do you think they are doing the work to scour through the behavior of each one of those corporations to determine exactly what they're using, what speech they're using their money for, so they can decide whether or not to sell their shares. It's sort of an unrealistic expectation. That would be the response, but that was the court's answer to the concern about shareholder protection. Okay, what about the concern that huge multinational companies being able to spend unlimited sums of money to support candidates distorts the political process? Well, that is what the court said in Austin, and that is what the court in Citizens United overturned its own decision back in the early 90s. All right. I think, should I stop there and give, it's just about 5, and I know there's a couple other speakers
2 more minutes
to talk. Okay. So just real quick, right, how did we get here? I have a piece that Hirak mentioned that I published a couple years ago in an NYU journal about my view of how Citizens United ultimately came into being, and that is, I trace it to the idea of freedom of association. And freedom of association has very deep roots. It is all the way back in the 1920s, the court for the first time said, well, free speech, there's nothing about association in the First Amendment, right? But we interpret the freedom of speech in the First Amendment to mean quite naturally that part of free speech is the ability to join with others, right? And the famous case from the 1920s was about a woman who was a member of the Communist Party, right? And the court said, we can imply that there's a freedom of association that comes out of free speech, the right to associate. And this makes sense, right? Intuitively, yeah, you join together with a group, that's how you convey a message. It makes sense that the court should say that this is deserving of some constitutional protection. But little by little, in this piece I wrote, I trace how the court gradually turned what was an individual's right to join in association with others to convey ideas into a right that belonged to the association itself. And this happened very gradually and without direct acknowledgement. But if you look at a case from 2002, like the Boy Scouts case, for example, I don't know if you're familiar with that decision, where the court said the Boy Scouts have a constitutional right to immunity from an anti-discrimination law in New Jersey that requires them to have, to not kick out a scout leader because they're gay. That this violates the Boy Scouts' associational right. As an association, they have a right to exclude individuals on the basis of their sexual preference. This is part of the associational right that comes from the First Amendment. Of course, that's a huge leap, right, from the idea that one, as an individual, has an implicit right to be able to join with a group like the Communist Party that has a particular set of views. So if you're interested, I would encourage you to kind of, I'd love to talk to you about it. Talk about my argument as to how we ended up where we did and how it's really a perversion of free speech. Because unlike Hirak, I tend to think that this is a decision that is not truly representative of what the First Amendment is intended to do. It's a distortion of what the First Amendment what was for. All right, so I will stop there though and pass things over just so everyone has time. Thank you very much.
Our next speaker is current director of programming at UD College Democrats, and before that, he was a general member for about 2 minutes before getting elected immediately after arriving at UD. A freshman economics major, he considers his idols to be Noam Chomsky, Richard Wolff, Karl Marx, and Thomas Piketty, author of Capital. His main interests include income inequality, free trade and the movement against it, and stopping anti-imperialism in the modern world. We will hear about the aftermath of Citizens Unite decision and how money in politics has in fact changed since that decision and the impact campaign finance and political action committees, known as SuperPACs, has had on the 2012 election. This will help us foresee what is coming in 2016, but with even more money in the system. A scary proposition, to say the least. Please welcome James Williams.
Hello everyone, I'm James, and as Danielle said, I will be talking about the influence of the Citizens United decision and the funding structures it created, specifically as they pertain to the 2012 and 2014 elections. So right off the bat, Citizens United enabled two main groups of spending. Super PACs, which are required by law to be independent of campaigns. In practice, this is not always true, but in purpose, it is true. And then the so-called dark money groups, which are nonprofit corporations set up by individuals, usually associated with campaigns, that are not required to disclose any of their donors. You can see why this is a problem, and I will go through the funding for the different elections. So in 2012, aggregating the spending between the presidential and congressional races, about $1 billion were spent by these outside spending groups, which is about 3 times as much as spending in 2008. Democrat-leaning groups spent about $300 million, and Republican-leaning groups, interestingly, spent about $720 million. So the funding was very skewed towards the right. About 80% of the money spent was in the form of attack ads. So I have numbers here. In the presidential election alone, $292 million were spent on attack ads against Obama, compared to $28 million supporting him. And on the right, $135 million were spent on ads against Romney. But interestingly enough, $100 million were spent supporting him. So this is evident of the bias in funding towards the right. With this funding, though, it's important to keep in mind the nuance in this, because this is only outside funding. In the presidential race, Barack Obama actually outraised Mitt Romney directly by about a factor of 2 to 1. And once party contributions are included, he still had more money directly. And of course, Obama won the nomination in spite of the amount of money spent against him. But these outside expenditures definitely encouraged Obama to raise more money than he would have, in that he held about twice as many fundraisers as George W. Bush did in his first term in office. So the funding directly isn't necessarily swaying elections, but the pressures on fundraising they're causing obviously is a problem. Now, in the congressional races in 2012, the effects we saw in the presidential election were definitely stronger. Several Senate races, notably Virginia, Wisconsin, and Ohio, saw independent expenditures of approximately $30 million each, spent again mostly on attack ads against Democrats. In these smaller elections, the influx of tens of millions of dollars spent on massive media campaigns encouraged candidates to fundraise more money. The aggregate cost of congressional races increased dramatically between 2008 and 2012, going from $2.5 billion in 2008 to $3.6 billion in 2012. And again, in the presidential election, the trend with the success of this money was again apparent. Despite the large Republican bias towards funding, Democrats gained seats in Congress, and generally the funding wasn't terribly effective at pursuing conservative interests, but the pressures on fundraising were noted, and that increase in funding between 2008 and 2012 is evident of that. It's not entirely clear who is donating this money, but super PACs, unions, and private corporations are the largest visible spenders. Super PACs in 2012 were largely funded by private corporations and by a few large donors, such as Sheldon Adelson, who actually donated $92 million to varying super PACs. And in terms of public corporations, they seem more hesitant to directly donate in that visible sense, just because it's bad for business, it's bad for shareholders if they're making direct political statements. But it's very likely that they're funneling money into nonprofit corporations set up under law by the Citizens United and related rulings. So we just have no idea if they're contributing. So I guess in short, with 2012, the influx of outside spending it did not visibly purchase the majority of these elections, but the funding pressures are making candidates more beholden to special interests visibly, and this is a problem. And we see in 2014 this trend accelerate with the congressional midterms. So in that cycle, Democrat-leaning outside spending was still less than Republican spending, but this time only by about $70 million. Yeah, $70 million. The structure of this funding was interesting to note, though, because Democrat spending was primarily from SuperPACs and visible groups that visibly disclose donors, such as unions and private corporations. But Republican-leaning outside spending was primarily in the so-called dark money donors, that is, the nonprofits that are not required by law to disclose funding. The direct fundraising gaps were clear, and so a lot of the Republican bias towards funding, again, didn't really do a whole lot in that sense. It was mostly catching up in a lack of fundraising, but even in outside expenditures, fundraising increased from 2012 this time. In North Carolina, $61 million were spent in outside spending. Colorado was $55 million, and Iowa was $43 million. And in a lot of these races, actually, we're in a system where outside expenditures exceed expenditures directly from campaigns. And you can see how this is a problem. You know, campaigns, as of now, are beholden to court special interests, even if they're not directly contributing anymore, because the media campaigns are influential, and while they're not directly swinging elections, the pressures are worrisome. And cutting to the chase in 2016, it is definitely early to be making these kind of analyses, but as I did my research, the trends are already fairly disgusting. About 3 times as much money has already been spent compared to mid-March of 2012. It's at about $700 million right now, and we are still months away from choosing nominees. It's also interesting to note that the majority of this funding is SuperPAC money. So also, this time, basically 100% Republican. Right to Rise USA, which was Jeb Bush's SuperPAC run by campaign managers, not explicitly in cahoots, but implicitly very much so. They spent $81 million trying to get Jeb the nomination, and we can see how that turned out. Marco Rubio's SuperPAC spent $55 million also. These are not, Jeb Bush spent a lot of money, but he's not in that sense an outlier, which is worrisome. On the liberal side, funding is there, or spending is there, but it's primarily from Hillary Clinton's SuperPAC, Priorities USA Action, but they only spent about $5 million. And so comparatively, most of the money being spent is very clearly Republican. In terms of fundraising, though, it's more even. Jeb Bush's SuperPAC raised about $120 million before he dropped out. And interestingly enough, Hillary Clinton and her SuperPAC has actually raised about $50 million. And so she is just sitting on a lot of money. And that just kind of shows differing election strategies, but it's very clear that the Republicans, throughout the entire history of Citizens United, have been the main ones exploiting this funding. However, I will digress that it's interesting to note that candidates with no SuperPACs or with little SuperPAC money are serious contenders for both nominations. You know, even Ted Cruz, who is currently, as of today, the Republican second place candidate, he's only spent about $1 million from the SuperPAC, which is, you know, compared to the hundreds of millions that have been spent, that's a drop in the water. Similarly to 2012, when Obama won in spite of this new source of funding, the candidacies of Trump and Sanders show that the traditional fundraising mechanisms, combined with a healthy amount of populism, are still enough to at least throw up a serious fight for the nomination, if not to win it. How long this will be true is uncertain, but even with the hundreds of millions of dollars being spent by these super PACs and by these shell corporations, our system clearly is not beholden to large unknown donors as of yet. You know, the pressures are there, but there is time before we live in a complete oligopoly. So we are running out of time, but in conclusion, I want to rehash, it is unlikely that outside contributions are directly swinging elections, you know, as evidenced in 2012, when in traditional fundraising, Obama outraised Romney and won re-election. But the rise of undisclosed donor organizations and the pressures in federal office elections that come from these multi-million-dollar outside media campaigns is leading politicians to seek more money than before, from fewer donors than before, who we know less about than before. The trends from 2012 and 2014 suggest a system where elections, when not completely settled by money, require candidates to expose themselves to more special interests to keep up with the spending from either truly or nominally so independent organizations. The system emphasizes the interests of a few over the interests of the majority, and while grassroots contributions are significant in a few presidential campaigns, notably Bernie Sanders, larger sources of money clearly dominate spending, especially on unsuccessful candidates, but I'm sure once nominees are chosen, we will see hundreds of millions, if not billions of dollars this time spent. And so in conclusion, the post-Citizens United election system is deeply troubling to me, and based on the trends I've exposed from 2012 and 2014, and already from this election cycle, it shows no signs of relenting. And that is my comment.
What? Alright, does anyone have any questions for Dr. Batchis, James, myself? Any complaints, any disagreements?
I do have a question.
Yeah.
So I think a lot of people, there's so many different ways for money to get spent in elections, federally, locally, and then campaigns and all these different things. Maybe we could draw on the board, right? So like the big difference. So like if this is a person, right?
Okay.
And they want to give money to another person, a candidate, right, directly, and let's, I don't know, we'll put like a little flag in his hand that he's the person running.
Sure.
So this money is regulated. This is limited. How
that
much
is-
you can give to this
It's
person.
like $2,000 a cycle or something. It's
Right.
very explicitly limited.
Okay. Now, if this person wants to give to a PAC, is that limited?
No.
Right.
Right.
Yeah.
So that is the super PAC. I didn't talk about the rise of the super PAC. This is the case, a case that shortly followed after Citizens United on the circuit court level decided basically that the implications of Citizens United are that PACs can become these monsters, right? Because I'm not using that language, but because basically, if corporations have the same rights as individuals to spend unlimited sums of money on their own speech if it's not coordinated with a candidate, and PACs are representative of the individuals who associate together to contribute to that PAC, right? Basically, they're just using the PAC as a conduit for their own unlimited spending, and so you end up with super PACs.
So I as an individual can give as much as I want to a PAC, and then when the PAC wants to give the money to this person, that's not limited either.
That is limited.
That is limited.
Yeah, it is limited. But, right, then there's the fact that a lack of coordination is really a farce. The FEC,
And
the
that's
Federal Election Commission, is supposed to
Right.
be in charge of making sure there's no coordination. They don't do their job, they don't have the tools to do their job. So the idea that there's a lack of coordination is just not.
Right.
I guess
And
just
there's
to
still-
illustrate the
But
difference.
technically they are not allowed to coordinate
That's what I
with
was
the
gonna
candidate.
say. that
This is just
there
a
is
contribution
difference.
then, right? He's not talking about expenditures, right? 'Cause PACs
Yeah,
can
this we're
spend.
still talking about.
So
I guess the-
Super PACs more, instead of
This is
directly,
contributions, and then I guess that is still a contribution.
Like,
Right?
no, super PACs can't contribute to candidates.
Right.
They can only, outside expenditure is the only thing. That's
Okay.
why it's mainly been media campaigns we've seen funded by that money. Because that's
Okay.
basically all they can do without directly coordinating.
Right.
So this goes more like that.
So
The
the-
media, okay. And also the difference too is like the PAC has to keep track of who their donors are, right? But super PACs don't.
Super PACs do. Super PACs have to report to the FEC, I think annually or biannually on off years and monthly during an election cycle. And so
Okay.
super PACs are transparent in that sense.
Although there are ways around that.
That's what I
Yes,
thought, that's
so
what I thought,
they're
that's how I thought the
501c4s.
final, yeah.
Yeah, and that's-
that's where they.
Those
don't
are
have to
those are the
disclose.
shadow money organizations where they aren't required to disclose their funding.
Right,
And
okay.
so
That's what I figured
it's a
out.
complicated mess, but that's the general
Yeah.
funding structure.
Okay.
Alright, any final questions?
Yeah, I have a question. So, one question that came up that was then addressed in Dr. Batchis' talk. So we're talking about contributions versus expenditures. In the contributions argument, limiting contributions was seen as a way to prevent corruption, and so that was something which was there before, right? But in talking about expenditures, this argument goes out the door because the idea is that you're then limiting speech, and this is not a corruption issue, it's more of a speech issue. But one thing that I was thinking about was that there is an argument that could be made, which was explicitly stated that was not being made by the Supreme Court and Citizens United, which is that by limiting the speech of some, or limiting the sort of the First Amendment rights of some, you're able to then ensure rights of all. So like, say I have limited economic means, so I can give as much money as I can for my candidate as within the limit, but if somebody else is able to give unlimited amounts, then that person is able to swamp my voice, and basically I don't have a voice anymore. So that even though it's really a corruption issue, on the other hand, it could also be perceived as sort of limiting my ability to have agency through speech. So that's an argument which is not being made in the Citizens United case, but I was wondering if you could talk about the history, like is that an argument which then been...
Right, so that goes back to Buckley, and the court says we will not accept the leveling the playing field argument. That is an unacceptable argument, and we're not going to balance away free speech in response to this view that there's disproportionate ability to speak, and that there's that this is about leveling things.
Right.
So so the court has explicitly rejected that argument.
Yeah, because it seems like the implications could be very problematic, but is there any case in the past where that sort of thing was more sort of, I guess, less unfavorable?
Well, I mean, you could say the idea behind FICA was explicitly about trying to level the playing field. That was one of the objectives behind the campaign finance law. But the court has really, in the most straightforward terms possible, rejected that argument. Now things could change, right? And we're in a moment where the court clearly is has changed, right? With the death of Justice Scalia, Citizens United was a 5-4 decision. In fact, interestingly, if you go back to Buckley, it was a lot of liberals, and a number of the liberals joined with the conservatives because, and this is the subject of my book coming out this month, a lot of free speech arguments that now, gradually now have become arguments we associate with the right, were arguments that the left embraced at one time when free speech was thought of as primarily sort of a left-wing cause, right? So you have a lot of the liberals in the Buckley period who were also concerned about the free speech implications of the campaign finance regime, and it's not crazy. Their concerns are not all crazy, but I think viewed in larger perspective today, looking back at Buckley, I think a lot of folks have changed their mind, and now you see members of the court, liberals on the court, saying maybe it's time to not only reverse Citizens United, but to turn back Buckley and what we did to campaign finance law in the first instance in the 1970s.
Starting fresh, never a bad idea. All right, Allison, and that'll be your last question.
So I was just gonna say, going forward, if there's obviously multiple presidential candidates who have come out, whether initially or later on, that this is an issue that they cared about. So I was wondering, what you would say to that candidate, whether you see as any of you, if you see a constitutional amendment as a solution, if you just see more legislation, maybe regulating the SuperPACs more so, what the solution to this problem might actually be, where you could get around Citizens United without the court actually turning it over.
Yeah, and the court might overturn.
Yeah.
I mean, I think honestly 5-4, and now we have, and 1 of 5 is no longer with us.
Yeah.
So and you have so much criticism of the Citizens United decision. The argument that kind of this conclusion, which is almost breathtaking, that there's no corruption as a concern. The corruption, there's no evidence that corruption is a real worry. To me, there's a really straightforward argument for the court violating the principle of stare decisis and saying we have to reverse Citizens United because it turned out the factual premises of that decision were wrong, right? So I think it could happen, and that we may not need to go down the road of a
I guess the death of Scalia just changed so much in this specific situation. It's totally altered the whole.
I think it's one of the reasons why this was such a contested thing. Whoever Obama appoints, even if it's a Republican governor from New Mexico, we're going to turn it down. Even if it's Brian Sandoval, we're going to turn it down. Even if it's someone who's clerk for Justice Sandra Day O'Connor and Judge Srinivasan were still going to turn it down. So yeah, Citizens United is now up for grabs, or it can be up for grabs given how Justice Garland, or assuming let's hope he gets nominated or confirmed, Justice Garland votes. So that, abortion rights, gay marriage, all that is really the reason why there's a contention. But this is definitely a big deal because Mitch McConnell, Mr. Turtle, is still around. But we'll just have to see how it goes.
And I think going forward, Citizens United and a lot of the funding structures we see are mostly an expression of a hidden feature in American democracy, which is control of the higher levels of government by the wealthy and by the influential. And so I think definitely overturning Citizens United and legislating these problems out of existence is wise in the short run. But I guess to directly address your question, candidates that are making this a central issue of their campaign need to have long-reaching plans to change the structure of our democracy, to make it more participatory and more direct.
It'd be really cool. The thing about Kennedy is, I like about 75% of him. He likes international law. He's very reasonable on the death penalty and solitary confinement. Gay rights crusader all the way. But sorry, Tony, but yeah, this is United. Not with you on this one.
Well, and even if they reverse Citizens United, going back to pre-Citizens United still wasn't great. I think the problem with
it was a compromise, like I said.
Just going back to pre-Citizens United and talking about legislating, Congress has spent the last 100 years, over a century, trying to regulate money in politics, and eventually the court always strikes it down. So, that's personally why I feel we really need a constitutional amendment, because, like you said, the underpinning of our government is with undue influence of people who have money and power. So that relationship is always going to be trying to get back, and I think it's crucial that we get something in our Constitution that protects that interest for the long term. So.
All right. Well, thank you all for coming. Can we get one last round of applause for our speakers? All right.
Awesome. Good job.
Thank you.
Good job. You too. Hey,
Yeah.
nice meeting you. I'm doing great things
Too.
for Professor Jordan.
Appreciate it.
Oh,
Thank you.
that's great. Yeah.